Is Gangster Act invoked against you? Dear friends, you no need to worry. You have to be very patient and try to protect yourself. You have to be aware about some rules of the Gangster Act by which you can help yourself. These common rules are known as UP Gangster Rules 2021, in which Rule 5, Rule 8, Rule 16 and Rule 17 will be very helpful for you. Dear friends, Gangster Act is a very draconian law and it can't be invoked in an ordinary fashion, that on the will of the investigating officer or will of any particular police officer, that you have to be prosecuted under the Gangster Act. This is the tendency in the present time, that the Gangster Act is invoked in very casual manner. However, honorable courts of this land become very strict, and therefore they do very a clean, or we can say a very hard scrutiny, that the in during the whether the during the invocation of that act these rules are complied with or not. We have to understand here that in ordinary cases a private person is a complainant on the basis of whom information or first information report, that is FIR, is lodged. But in the Gangster Act, informant is a police itself. But be remember, it is also a good for you, because if any information is false, then police officer who is informant of your case is a liable, and a disciplinary proceeding under the service rule will be taken against him. So law makes such rules that there may be a balance between the personal liberty and public peace and harmony. So what we have to look, whether there is a joint meeting held between the head of the police administration and district administration, meaning thereby there should be a joint meeting of senior superintendent of police or district magistrate, or superintendent of police, district magistrate, or commissioner of police and district magistrate. If it is not, then your FIR is going to be quashed by the court. What is the meaning of joint meeting? It has been, by the procedure, it has been held that additional superintendent of police, or as the case may be, will forward the gang chart after recording the satisfaction that all entries made in the gang chart is correct. So according to the rule 8, if any entry is wrong in the gang chart, then that gang chart is liable to be quashed, because a senior police officer is recording his satisfaction that whatever information is in the gang chart, that all are correct. And if you can able to prove or show to the court that the entries made under the gang chart act gang chart, then that gang chart is liable to be quashed and in the violation of rule 8. Then when the gang chart is forwarded to the senior superintendent of police and district magistrate for joint meeting, the rule cast and rule 16 and 17 rule cast the duty, onerous duty on the head of administration and head of district police, that they will again peruse all the record affixed with the gang chart and apply their mind independently, record the satisfaction that the case is liable to invoke for the Gangster Act, and then recommend it for registration of the FIR. If there is a rubber stamp printed pro forma, date is different, or there is no date affixed, these all are the grounds for the quashing of the first information report under the Gangster Act. Further, some major details must be in the gang chart, such as the cases must be mentioned on the basis of which the gang chart is forwarded. Further, there must be clear entries that when the charge sheet is filed in the court. If the gang chart is prepared before the filing of charge sheet, then again it is liable to be quashed. Furthermore, if the base case is more than 3 years ago, lodged more than 3 years ago, and after the expiry of 3 years, that case is used to invoke the Gangster Act, again the FIR is liable to be quashed. Further, there is an entry that how many cases are registered against the person against whom Gangster Act is invoked. There must be clear number mentioned. Further, there must be mentioned the status of the gang members, whether they are in the jail or they are on the bail or on the anticipatory bail. If these entries are wrong, again the Gangster Act is liable to be quashed. So dear friend, be aware, be careful, watch very properly your gang chart and FIR annexed there too. And further, one more important point is that when the joint meeting will be held, how a person can be known about that there is going to be their authority is going to be invoked gangster against you. Whenever a joint meeting held between the head of the police administration and district administration, then after that there must be a press release that look, these are the members, we have taken a meeting and we found that these members are doing a illegal act by making a gang and taking undue advantages. If there is a press meeting, then it would be hard for you, but if there is no press release after the meeting, then gang chart is going to be quashed. Your FIR is going to be quashed by way of writ jurisdiction. Apart from that, earlier when the anticipatory bail is enacted again in the state of Uttar Pradesh, it is mentioned that anticipatory bail is barred under the Gangster Act. So as a person, your only remedy what you have is to challenge the FIR and get stay on the proceeding. But after the repealment of Criminal Procedure Code with the enactment of Bharatiya Nagarik Suraksha Sanhita, under the provision of anticipatory bail under section 483, there is no bar, there is no such amendment as particularly for the Gangster Act. So the Lucknow bench of Allahabad High Court continuously maintained the anticipatory bail application and decided it on merit. Further, if there is only single case mentioned against you in the gang chart, it is also a very nice ground for getting stay on the arrest. So be careful, try your luck, try your first chance with serious study by invoking Article 226 criminal writ jurisdiction. Most of the time you will get succeeded, and if you not, then go for anticipatory bail. Don't misunderstand that in present time anticipatory bail is not maintainable. In present time, anticipatory bail is maintainable in all those cases which was earlier barred by the Criminal Procedure Code. Thank you.